6:30, so we'll go ahead and call this meeting to order and ask for the roll to be called, please.
Eisenman,
Here.
Furtado, Goss,
Here.
Patterson, Thorsland, Dillard Myers, Esri.
Here. We do have a quorum, and Eric Thorsland sent an email a little earlier today that work had gotten in the way of his being here tonight. So he didn't expand any more than that, and that's fine. Just thought I'd mention it. Okay, move on then to approval of agenda and addendum. Is there such a motion? Moved by Mr. Patterson, seconded by Mr. Goss. Anybody want to change anything or seeing none? All in favor, please say aye. Aye. All opposed, nay. Thank you, that passes. Approval of minutes from the November 7th, 2019 meeting. Is there a motion to approve? Moved by Mr. Patterson, seconded by Ms. Eisenman. Are there any corrections, additions to be made? Seeing none, all in favor, please say aye. Aye. All opposed, nay. Thank you, that passes. Public participation. We'll remind the audience members that we're asking you to keep your comments to 5 minutes or less. And I have Miss Gina Pagliuso. Pagliuso. And this, if you could turn the microphone on, please, the closest button to you. Yep, there you go.
Thanks. Thanks for your time, first of all. My name is Gina Peluso. I live at 806 South Vine here in Urbana, but I work at 4106 Fieldstone in Champaign. And I sent all the members of the committee an email early in November, just making you aware that we continue to have a problem with the township's burn pit. And then I didn't hear back from anyone, so I resent the email December 27th. And what prompted me to do that was on my drive to work that morning, there was just a plume of smoke coming from that burn pit. I had, in the past, I had gotten in touch with the Illinois EPA to find out if there was, in fact, a permit. And for a long time, it appears that there never was a permit. There was one that was issued in 2018, November 26th, and I think I noted that in the email that I sent to you all. It did expire November 26th of this year, which is the date that the township applied for another permit, which was then permitted or approved on December 4th. There were 12 conditions on the original permit, and I felt after the permit was approved the first time that there were many of the conditions on that permit that weren't met, and went over to the township on a few occasions I think I've been there 5 times over the last 4 years, to the township meeting itself to let folks know that we were continuing to have a problem breathing in that smoke. We have a dock door that we have to open to receive materials and to ship materials. All of our HVAC systems are bringing that air in. So all of that smoke and the smell goes into our HVAC system, and we are a captive audience. We're at work 8 hours a day, and if they're burning first thing in the morning, we smell it all day long. I do appreciate that the township has gone to the measures of making sure that they have the correct permits. And my reason for coming to talk with you tonight is because I believe when you passed, I believe it's Ordinance 984, which was the addition or the addendum to the Nuisance Ordinance. I know that the township is exempted because it's a local government body, but when that ordinance was recommended to the full board, I don't believe that there was a burn permit in place at that point. And I feel like the Environmental Land Use Committee maybe should have taken that extra step to make sure that before you codified that into law to allow them to be waived, that you made sure that they were meeting the EPA requirements. So, as I mentioned, we continue to have this problem. Yesterday, there were big plumes of smoke again. I took pictures this morning when I went to work. Again, the burn pit was going. So I know it's very economical for the township to remove their landscape waste in this manner, but it's affecting the people that work north of that. There's an assisted living facility that's less than 800 feet away. The permit says that the pit should be 1,000 feet away from any populated area. We're 860 feet, and there are other businesses that are closer than that than we are. Um, I know that when the township started burning, there weren't a lot of people living out there. There weren't a lot of businesses out there. My business, I don't own it. I work there. Metrotech has been in that facility for 20 years, and I think it might even predate the air curtain destructor that the township has. There used to be a very large grain elevator on Springfield, and that would kind of block the smoke from coming in our direction, but that's been gone for 10 years. So I'm really here to see if we can come to some kind of a solution, some kind of a meeting of the minds, so that the people that work in that area and that are captive don't have to deal with this every day. I applaud you for helping the residents that were having this problem with their neighbors, the people that lived across the street. But what it did was it forced all of that land waste into the township's burn pit, which then affects us. I did call the city of Champaign today. They've processed over 160,000 bags of landscape waste that they picked up this year. They have 2 farmers that come and take all of that land waste away and use it on their farms for their animals, for, however they can use it, they use it. I'm not trying to get the township to stop burning, period. I know that there are some times that they're going to have to. But the ordinance that was passed prevented the individuals from burning, but moved all of that waste into our airstream. And one of the things on the township's, and I know I'm probably up to time, one of the things on the township's website says, please respect your neighbor's airspace. And that's talking to the neighbors that live in those areas. But we're neighbors also, and our airspace is not being respected. So I'm here to ask you to help us find a solution. So I appreciate your time, and I appreciate your attentiveness. Mr. Hall, I appreciate that you got back to me and that you got this item added to tonight's agenda. And I'm more than happy to stick around till that item comes up if you have any questions.
Thank you.
Thank you.
Mr. Paget, do you wish to speak? Mr. Keith Paget.
Good evening. Some of you are a familiar face, some of you not. I've been over here several different times for different issues. Some of the housing issues in the subdivisions where they might have been burning and got that resolved. And yes, we do take that debris, yard waste, wood items, leaves that we dispose of from Champaign Township property. I happen to put together a little list of things here that I do keep a log of this. In the year of 2019, Champaign Township burned 24 different days. We don't burn every day. We burn when the wind is coming from the north. We try to keep that from going across the Route 10. And yeah, that's the reason that elevator was there so long, that we didn't burn when it blew that way, so it wouldn't catch the elevator on fire. So 24 days in 2019. The wet items, which tend to come here in the fall, we haul those off. Wet bag leaves do not burn very well anyway. In 2015, we had $4,596 cost hauling those bag leaves away to the LRC over here in Urbana. This year so far, we spent $20,510 hauling unburnable wet leaves away, partly because they didn't want bag leaves. They don't burn very well. Even in an incinerator, they don't get enough air. They're like a big cigar that burns, so we haul those away. So, and I've got another at least $6,000 of receipts coming from the LRC, which is run by Urbana, and they charge the township, same thing what they charge the residents to haul that items in there, except we haul them in there in the dump truck. So if you can get me a discount over to LRC, we'll try to take more of that over there, but we're simply burning the limbs and the trees that we take down in the parkway, which a lot of that was from the ash borer situation we had this last year, burning those trees up. For you people who watch the news a little bit, we did have what turned out to be a EF0 tornado hit the Rolling Acres subdivision down there last year. We had I think we had over 70 dump truck loads of limbs and stuff to come out of there. So that's the way Champaign Township disposes of that when we were out, when there wasn't anybody around. Now we have to wait on the wind to be the right direction to be able to burn and get that to go where it doesn't offend too many people. Any of you have burned, you'll know this time of year there's a lot of difference between smoke and steam. You get something hot and it's got the moisture in it, it's going to release it. All what you see is not smoke. A lot of it's steam. When that debris is burning up, it's burning the moisture out of it. But it looks like smoke. So, any questions?
We're not set up to take questions
No problem.
back and forth at this point in time.
Sure.
Excuse me. When it comes up on the agenda, we'll be able to ask questions then if
Thank you.
any of the committee members have something.
Thank you.
Thank you. Anyone else care to speak during public participation? Seeing none, we'll move on then. We'll close that and move on then to 6, communications. Are there any communications need to come before the board from the committee members or staff? Anything? Speak into the microphone, please, Connie. Thank you.
One thing that I didn't want to mention is I would have preferred to have been at the meeting at the city building with Carol Ammons and them rather than here tonight. But I know the meeting is important. You want to cancel it twice, but I just want to mention that they are holding that meeting. And I wasn't able to go. I would have liked to have gone.
Yep. Yeah, on the jail issue mainly. Yep. Thank you. Any other communications? Okay, we'll close that. We'll move on to 7. We have new business, items for information only. We have A, the e-waste collection for Champaign County residents in 2020 and beyond. Ms. Monty, please.
Hi. This year's report about e-waste collections in 2019 takes it to the next level and looks to the future. So in addition to getting information about trends over the past 5 years, I've provided a look at both options that the county and local governments can consider as we move forward. We can continue to have these one-day collections twice a year, or we can move toward having a program collection site. And that's what this memo contains, a lot of preliminary data about. So I just wanted you to have that before you. I'll just briefly mention that the trends indicate a steady high participation rate by residents, continued high volumes and weights collected, and amounts of TVs collected holding at approximately 66% of total e-waste collected at these events. So those are the general trends. And so I personally would like to look more at locating a host site for a program collection site that the county has the option to look at, and I would like to talk more with the municipalities and our staff equivalents there to get their buy-in and collect data more about an operator, what the cost would be to operate such a program collection site. So once that happens, this will be back before you. This is a preliminary kind of information report to get some of this information out there and to let you know that we're looking at both options, not just continuing the one-day collections. And I did pass out 2 attachments that contain a lot of data. The one that I would encourage you to take a look at that's easiest to absorb would be the benefits and limitations of both options, attachment D. And so you see that if we had a program collection site, it would be way more convenient for residents, year-round availability, less local government staff time and local government resources would be required. It would not be as weather dependent either. So that's some of the benefits of a program collection site. Limitations would be, and changes if we had a program collection site, might be that we require residents to pay a nominal fee of $10 per TV. And some municipalities may choose to implement a voucher system so that their residents would not need to pay that $10 per TV kind of thing. A dedicated location and part-time staff. So yeah, there's a lot to look at, and I wanted to start to bring this information forward. It's information at this time only. Thanks, and if anybody wants to talk to me about this or has ideas about a potential program collection site, that would be awesome.
Thank you. Any questions or further discussion from the committee members? Or Mr. Rosales? Oh, go right ahead, Geraldo.
Yeah, I did anticipate this question. So if you look at attachment C, I added a section there. And my hours in last year, for example, were about 150 hours to coordinate and get this together. That includes a lot of stuff. That includes trying to get contributions from outlying municipal communities and organizing meetings amongst the contractor and local government officials. I mean, we have this down pretty much to a well-oiled kind of thing that happens, and we can keep doing it. But I think the costs outweigh the benefits. So yeah, approximately $7,500 is spent by Champaign, by the probation and court services. Champaign County Probation and Court Services is about half the county resources here, and the other half is my resources and time. So, and then City of Champaign contributes even more than that each year because of their population-based contribution to the cost share agreement. That's why that is so high. So yeah, it's all broken down. There's a cool little chart here at the back here. Yeah, I think it's important to know what we're doing and look clearly at our both options as we move into the future.
Oh, now it came on. Any further discussion? Seeing none, we will then move on to B, Champaign County Environmental Stewards. Ms. Monty again, please.
I thought the county board would like to know about this nonprofit that was formed during 2019. It's a nonprofit that is looking and seeking to raise money and awareness to fill the gaps that are not being met by our current local governments. So its mission is to assist in finding solutions and improved options for collection of difficult materials, such as household hazardous waste and hard to dispose of stuff at the end of their useful life, such as like mattresses, other burdensome items that households typically have to deal with. Just making that more easy and more convenient for our residents. Also to operate and maintain a website that can serve as a central information resource for the entire county. So, because right now people have to look, and a lot of people don't realize that information exists on the Public Works page of the City of Champaign, or here on our Champaign County, our webpage. It's sort of like scattered all over the place. So this is nonprofit. One of their education mission programs is to operate that website.
Thank you. Discussion on this? Seeing none, we'll move on to 7C, Notice of Noncompliance with Illinois Noxious Weed Law. Mr. Hall?
This is our annual notice from the state that we're not complying with the noxious weed law. I've mentioned in the past that this is probably the third year they've sent out these notices. I'm only aware of one county that actually has never received a notice like this, and they do have a year-round noxious weed program. I'll answer any questions you might have, but in my view, the noxious weed program for compliance, you have to survey the county every year to see where the noxious weeds are and have a plan for removal every year. You have to have a superintendent appointed to do that. And that's a big program.
Money and time.
Money and time.
In terms of employees.
The way Champaign County handles it is if we get a complaint, we'll investigate, determine if it's a noxious weed, send out a notice. Everyone I've ever sent a notice to has responded. I didn't even get a complaint this year, thank goodness. I know there's plenty of noxious weeds out there. They're everywhere. Most of our noxious weeds complaints come from, frankly, neighbor wars. Nonetheless, people do take care of it when we tell them that we've gotten a complaint. So as compared to the rest of the complaints we get we get really good compliance on noxious weeds when we have a complaint. Doesn't comply with the state program.
Go ahead, Stephanie. Microphone on, please. Thank you.
Is the noxious weed like in somebody's yard, like that kind of complaint, or is it like garlic mustard invasive species? Like which is it?
Well, the noxious weeds are identified under administrative rules.
Okay.
I think there's 8 noxious weeds. They're not, they're worse than invasive, I guess, because they've actually been determined by the state to be noxious. But for example, this year, a citizen complained about noxious weeds in the commons area of their subdivision.
I remember that.
Yeah.
Can you give me an example of a noxious weed?
Canada thistle is the most common one.
Oh, okay. Yeah.
I think burdock is also.
Okay.
And there's so much burdock in my neighborhood in Champaign so it's really everywhere. Nonetheless, we get good compliance when we notify people.
Did you find them, Jim? I know you said you were looking. I heard you say you were looking. You just,
Yeah.
Go ahead.
Okay, so it's common ragweed, giant ragweed, marijuana, musk, Canadian thistle, kudzu, perennial sow thistle, Columbus grass, and Johnson grass. And if you want to ID those grasses, I've got a nice little handy dandy thing to help you ID those if you're really looking.
Get turned on. Thank you, Jim. Further discussion? Okay, seeing none, we'll move on then to 7D. Complaint of open burning at Champaign Township property. Again, just for information only, I guess start out, John, do you have anything you want to add off at the beginning?
No, I think Ms. Paluso and Mr. Paget gave good summaries at the beginning of the meeting. I don't know what the county could do in this instance. I hope the county isn't going to try to start regulating townships. I don't even know that the county has that authority if they wanted it. Frankly, I don't have any solution for this problem other than to hope that the township has good luck in operating its burn pit to minimize smoke.
Thank you. Does the committee have any further discussion or questions for if they're willing to step forward? I mean, if there's no objection, we'll let questions be asked of Mr. Paget and Ms. Peluso, if so desired. If anybody has it, Mr. Goss.
I didn't really have a question, but John, you answered what my question was. I'm not real sure that we've got much authority to regulate a township, and that, I mean, I just don't know that we have that authority. I mean, I've read enough of the state statutes to want to go to sleep most nights, but I nowhere in there do we have authority that I found to regulate townships. I'm not saying it doesn't exist, but I don't believe we do.
Thank you. Anything else? Go ahead, Ms. Furtado.
The addendum to the nuisance ordinance that was talked about to the 984. What exactly did that addendum do?
That established prohibition on residents burning leaves if they're in a township that provides an alternative, was essentially what it amounted to. And Champaign Township is the only township that I'm aware of that provides an alternative way for residents to dispose of leaves.
Ms. Eisenman, do you have a microphone, please?
I was just saying, I think Keith wants to say
Oh,
something. maybe.
Mr. Paget, did you want to care to say something? If you would, so we can get on the record. Yeah, go right ahead. And if you have something else to say too, Ms. Blues, go ahead. I'll give you the opportunity to.
Keith Badgett, Champaign Township Highway Commissioner again. For those of you who do follow the paper, of recent this last year, St. Joe had an issue with their burning of debris right there on the south side of 150, right there by the Stall Fork River. There's always somebody in the line of the smoke. So their alternative, they rented or purchased a portable burn unit, which it's a trailer, you pull up there and the wings come out and you turn it on, it blows air. The trick to this thing is to put more air to it to make it burn hotter and less smoke. So St. Joe town, maybe the village of St. Joe, has also incorporated a burn unit for their debris out there.
Mr. Rosales.
Is there any possibility to shred or mulch some of those trees and leaves, especially the wet ones, and then give the debris to the public for the spring so that they
Well,
can use it for
LRC does that at a cost. And we don't really have the property to do a big project like that. By the time you set up some sort of a grinder, which costs a lot of money, our Christmas trees, we're taking those out to Lake of the Woods so they can put those as fish habitat once they get enough ice to get out there on it, or they're mulching those up to put as mulch under their trees in the Park Service. So the trees that we take down, like the ash borer trees, are already on the verge of being dead. So they're not juicy by any means. They simply burn up pretty easy. You'll get a storm, you get a limb down, it's still got some moisture in it. When you get it hot, that steam comes out because the moisture is evaporating away. So that's what you see. Now there is some smoke, but then a lot of it is just simply steam. But we don't have the property to be able to function with that, especially when Urbana has the entire old landfill to make that work out there for them.
What are your burning hours?
We burn somewhere from 7 o'clock till 3 o'clock. When I start that off, I call the METCAD number, which is 333-8911, and they're very familiar with it. Champaign Township Road District, 3900 Kearns. We'll be burning a burn pit for a while today. I'll call you this afternoon when we're done. I call the number 6 firehouse, which is the one most likely to have a response, 403-7370. Every time I burn, and call them every time that we get done. So we burn during the daylight hours.
Thank you.
Thank you.
Ms. Furtado.
You said you sent stuff on over to Urbana that cost about $20K, plus you think another $6K receipts are coming. About what percentage, if you could ballpark, of your total waste was that?
It's probably not half. The bulk of that is street leaves. We ran a street sweeper for 3 days here trying to get ahead of this rain. And a lot of it is bag leaves once they get too wet to deal with. Talking about the farmer that comes get it, I had been in contact with that farmer. He's up by Penfield. I did a test run, took a dump truck, fueled it up, drove it up there, drove it back, $84 a load. That's even higher than going out to the LRC in Urbana. That guy doesn't seem to be interested in a small percentage of leaves like he does for the city of Champaign. And I haven't talked to anybody, but I'll bet they're not coming and getting it for free. Now, they're using it to bed cattle with up there at that operation. I've been there, looked at it, but I bet they're not coming getting it for free. Could be wrong. But I contacted him, and he didn't seem to want to help with our situation there. So we take it to Urbana. Thank you.
Thank you. Ms. Blues, give Mr. Paget an opportunity. We'll give you the opportunity too. And if the committee has any questions, if you're willing to answer them.
Thanks for the opportunity.
Go right ahead.
So when I spoke to the city of Champaign, I just called and asked what they do with their leaves once they're picked up. I'm not suggesting that Mr. Paget drive the leaves up there. From what I understand from the city of Champaign, they come to Champaign and get them. So maybe we can work out something where they, while they're here, could also go to the township and pick up what they have. I'm looking for a reduction in the amount of smoke that we have to breathe in as we're working. During we're in our slow season right now, but during our high season, we're a testing company. we employ a couple hundred people from May till September. And all of those people have to deal with this on a day in and day out basis. We had 60 people that signed a petition 2 years ago that are people that work there every day that have asthma and migraines. And I'm looking for a solution to the problem. I'm trying to find something that'll work for everybody. And I don't know what that is. I know that you, as a government, don't have authority over the township, but you certainly had authority over the ordinance when you passed it, when you recommended that it be passed. And so that's why I come to you for help. And if you have any questions, I'd be happy to answer.
Are there any, Ms. Eisenman?
Hi there.
Hi.
You had mentioned that the conditions on the permit were not being met by them. And so
Yeah.
what ones specifically?
So, and that permit, the new permit actually has the conditions are changed a little bit. But the original permit that was issued in 2018, and I repeatedly went to the township and asked them for their permit, and I got a couple of emails that said, we're waiting for the EPA, we're waiting to hear back from the EPA, and then I finally got the permit. Let me see if I can find it. Okay. Oop, I had one that was marked up. Apologize. Okay, so precautionary methods to minimize the emissions of air contaminants from the air curtain destructor. That was number 2 of the 12 special conditions. Number 3, only tree stumps, trees, tree limbs, and bark may be burned. So it didn't include leaves at that point, but there were bags of leaves piled up there. Number 4, the pit should be located at least 1,000 feet from a residential or other populated area. Number 5, burning shall take place only when the wind is blowing away from roadways, residences, railroad tracks, and populated areas. And Springfield Ave is only about 400 feet from the burn pit. So if the wind is blowing from the south, like it was this morning when the burn pit was operating, and yesterday afternoon when the burn pit was operating, the smoke blows right across Springfield Ave. I've seen it blow across 57, which is, 1,500, 2,000 feet away if I had to guess. Number 6, prior to the scheduled burn, the permittee shall notify residences and businesses that might be affected. We were never notified. And when I went to the township and presented these highlighted issues, I was told that we would never be notified. And the permittee shall notify and receive, this one he actually did. So there were 5 of the 6, I apologize. So those 5, I believe, weren't being met. As I mentioned, the new permit's a little bit different. Instead of shall, things are should. But should is still a recommendation, and a lot of those special conditions are on the new permit also. Thanks for asking.
Anything else, committee members? And you have nothing else?
I just want to thank you for your
Thank you.
time, and
Thank you.
anything you can do to help with the situation would be greatly appreciated.
Thank you. Okay, thanks. We'll then move on to 8, new business items to be approved by ELUC. We have A, the annual renewal of recreation and entertainment license, and if there's no objection, I'll just do these first 2 omnibus. We have the first one, Hudson Farm Wedding and Events, LLC, 1341 County Road 1800 East, Urbana, Illinois, 61802, from 1/1/2020 to 12/31/2020. And then we have 2, the Champaign County Fair Association, 1302 North Kohler Avenue, Urbana, Illinois, again from 1/1/2020 to 12/31/2020. Is there a motion to approve? Moved by Mr. Goss, seconded by Ms. Eisenman. Discussion on these. Not expecting much. They're seeing none. All in favor, please say aye.
Aye.
All opposed, nay. Thank you. Those pass. Then we have B, the annual hotel motel license for Urbana Motel Incorporated at 1906 North Cunningham Avenue, Urbana, for 1/1/2020 through 12/31/2020. Is there a motion to approve? Moved by Ms. Dillard Myers, seconded by Mr. Patterson. Discussion on this. Connie, I don't know if you. This is the only hotel motel in the county. To let you know, if you didn't know it, okay. Well, good. You already knew it, so okay. But yeah, it's the only one we have. So, only one we have to approve. Okay. So, all in favor, please say aye. Aye. All opposed, nay. Thank you. That's approved. We'll then move on to C, direction regarding proposed zoning ordinance text amendment for adult use cannabis zoning regulations pursuant to Public Act 101-0027. Does someone care to make a motion, or do we want to just discuss or start the discussion off? Or Mr. Hall, if you want to make any comments first, I guess
Well, there's two proposals here. One is basically to allow the cannabis-related businesses only within 1.5 miles of Champaign and Urbana, which are home rule municipalities with more than 20,000 population. That's attachment A. That's the basic amendment. Attachment B modifies that for cultivation centers, craft growers, and for transporters. It goes beyond that area, but it keeps everything at least 1.5 miles from any municipality that doesn't allow these businesses. And it keeps them 1.5 miles from any residential district out in the area. So those two options. There's also this thing about when a cultivation center or a craft grower is within 300 feet of a dwelling or a residentially zoned property. This amendment uses the standard that Urbana requires, which is that it needs to be a special use permit. In the city, special use permit is approved by the city council, and so to use that in the unincorporated area, you could make that a county board special use permit, which is only required for wind farms and solar farms, or you could leave that special use permit at the zoning board, leave it up to the zoning board. I can say right now, this has been one of the more controversial amendments I've ever dealt with, so you might want to keep it at the county board rather than rely on the zoning board to answer those cases, but that's up to you. Champaign County has historically relied much more on its zoning board than any other county, so two basic amendments, and then there's this thing about the special use permit. But the basic amendment limits it to only within 1.5 miles of Champaign and Urbana, and then requires that special use permit. I think, actually, I need some direction from you on the special use permit. I forgot to make that alternative A different. So, no, it's county board approved special use permit, sorry. So the basic provision is only within 1.5 miles of Champaign, Urbana, and any special use permit must be county board approved.
microphone, please, Connie.
This is for retail or dispensaries?
Dispensaries as well as craft growers, cultivation centers, infusers, processors, and transporters.
Okay, what about beyond that? Just the regular county? Maybe I'm missing something. I'm not getting what you're saying.
Well, we're defining these as the kinds of cannabis businesses that we would allow. Cannabis can only be sold to the public at a dispensing organization. Cannabis can only be grown at a craft grower or cultivation center. A dispensing organization can do infusing and some processing, but you can also have businesses that specialize in just that. And then you have to have a special license to transport. So I'm not aware of any other cannabis-type businesses that we need to include in this amendment. And again, the basic amendment would limit any of those to only within 1.5 miles of Champaign and Urbana. And then the
Nowhere else in the county, you're saying?
right, but attachment B would allow cultivation centers and craft growers and transporters to be further out in the rural area in the proper zoning. Now, transporters, there's 2 ways to go with the transporter. Basically, it can be in a B3 or B4 district, or you might have someone wanting to do transporting as a home occupation. I think that's possible. And so that would be possible in this alternative B. You might have someone that lives far out in the rural area, not within 1.5 miles of any residential district. They might want to try to be a transporter as a home occupation. But you're not going to find B3 and B4 zoning out there.
Anyone care to speak to any of that or throw out their own opinions? Mr. Hall, go ahead.
Well, there's even a possibility that you could send both of these to a public hearing at the zoning board and then see what you get back from the zoning board.
Mr. Goss.
Yeah, so whatever we send, we're sending this to ZBA for hearing to the public, comes back in however much time it takes. I mean, we don't control that, and we don't have any idea where their backlog is, so this could be more than a month, probably.
It's going to be more, it's going to be at least 3 months before you would see this back here.
Okay. I mean, I'm a little torn on this. I kind of am more supportive of A than probably B, but it's whether we send both to ZBA. I guess I would ask the committee maybe to share what their thoughts are. I mean, I'm supportive of A. I'm not all that supportive of B, but
Being chair, I know the general idea is you don't speak too much, necessarily a whole lot, but you just run the meeting. But I'll go ahead and first off, I'll ask John. Now, the cultivation centers and such, do those fall under agriculture, or has that truly been defined yet at the state? Because there's the idea again that we can't regulate agriculture.
We can't regulate agriculture, but the state has clearly anticipated that we could that we may be interested in regulating these. So I'm operating that we can regulate this. I still haven't heard from the state's attorney. But I'm prepared to move ahead with this at the committee's direction.
Okay, thank you. So I'll go ahead and throw out, I guess, my ideas. I can support A, not a problem, personally. Yes, to go ahead and throw out my ideas. The whole idea of legalizing it, people are using it already, of course. You're not going to stop it. I mean, people always use the idea of probation didn't stop the alcohol consumption. That's true. You aren't going to stop marijuana use. There is demand for it. It's here now. Now that it is here, I don't think there's ever turning it back to where we're going to totally say it's illegal again. I just don't see that happening. So I can live with A again, like Mr. Goss says, no problem. Yeah, you do get into B. That does get to be a little more of a, it's not quite as desirable to my way of thinking. But cultivation centers and such, that is more just the growing. It's not people running out there every day forming not that the lines are going to keep being this long, but there's not going to be, but there's not going to be lines of people going out there. You're not going to have the traffic out there going to other than the people that are working there. And if they're, you just aren't going to have the issues with the public being out there. It's going to be the people who are working out there who would be there on a day-to-day basis. So that would eliminate some of the issues with like a dispensary out in the county. We as the county board, we speak for the people who are in the unincorporated. That goes for everybody on the board. It's one of these, it's like, I guess, I mean, ultimately my vote doesn't count any more than anybody else's, but yet I'm living in the unincorporated. And I have no one coming to me clamoring, give us dispensaries, give us all this, give us these marijuana businesses out in the unincorporated. Now, I'll also say I personally haven't had anybody contact me directly saying ban them all. But again, I don't hear the clamoring either way. So I can live with B. It isn't as desirable to me, but I don't think it's not going to be the end of the world if we would happen to get a grow center out in the county, appropriately zoned and everything. And if it, as far as the special use permit, I think I would agree that this is a controversial enough that keep it at the county board level. That's a pretty high standard the way we do it, since we currently only do it for wind farms and solar farms, but this is a big enough issue. I think, personally, I'd say keep it at the county level. Those are kind of my thoughts. I mean, I don't know if I could maybe try to expand on if somebody else wants to ask me some questions, but go ahead, Ms. Furtado.
So, John, thanks for your explanation. I think that, and it's not going to come as anybody's a surprise, that I'd be more supportive of B, and I think B is more indicative of the sort of the compromise that Pranjal suggested at the meeting, right? The concern that we heard a lot at the full board meeting was around dispensaries. And so essentially what Pranjal said was, well, what if we took dispensaries off the table in the broader county? And it wasn't, what if we took dispensaries off the table, except for the 1.5 miles around Champaign, Urbana, and, had all the business right around that. So I think that B, I could see B possibly passing the full board. I don't think A is going to. And so I'd be fine with if y'all want to send both to the ZBA and get more public comment. And, there's 6 of us here, like there always is in this committee. So it's probably going to be a tie, and I don't even know what that means. But I think, just to be frank, when it comes to the full board, B is probably the one that's going to have more likelihood of passing. And I think that is a compromise from, like, if it was me, like, it would not be either of these. It would just be legal, right? And so, but I do think that another part of the compromise could be the special use permit and keeping that at the county. And that gives us another chance to sort of rigorously look at things. So it still gives us decision-making power, right? Through the special use permit. And I feel I think that's a pretty fair compromise.
Thank you. Anyone else care to? Ms. Eisenman.
I would very hesitantly be able to vote for A, as you've heard my case for it all of the times before, all of these months. B, it bothers me to say that it can come into the unincorporated areas when these communities obviously don't want it. And so it floors me that A, we're the first state to have government legislation on it. And so just because our governor wanted it and made it legal for the whole state, if a different governor would be put in place, it may not have been legalized. And so my whole point is, not everybody is jumping up and down for this. Right or wrong, it's the truth. And so I have had people contact me that are against it, that live in the unincorporated areas. I live there. My family lives there, extended many ways, different areas. And so my thought is, A is a compromise from not prohibiting it to now allowing it to be in the area that is legal and does want it. And so it can be a mile and a half within Champaign and Urbana. And again, I'm going to go back to what I've said from the beginning. This is all brand new. So why don't we slow down and just slowly, it can always come back if we're like, well, we need to get it going out in the rural areas further, it can come back in a couple of years. But let's see what happens first. Just like when Chick-fil-A opened, there's lines for days. Like, it's slowly gonna die down. I mean, it's all so new. We have 12 months to make the decision. Can't we just, okay, we can allow it out within a mile and a half of Champaign and Urbana, see how that works, learn how to regulate it. I will say this 1,000 times. My dad's a farmer, my husband's a farmer. My husband would scout crops before marijuana was even legal. There would be people growing it in the middle of a farmer's cornfield. Unless you are walking the fields, you don't know that, and they would harvest it before the farmer would harvest. There's no real way to regulate or to monitor and to make sure that it's legally being done out into these rural communities. And so I'm just saying, let's get a handle on it first in Champaign and Urbana, see what's happening. There's always going to be the illegal side of it. I'm a realist, I know it. And so I would support A. B, I will not.
Thank you. Further discussion. Mr. Goss.
Yeah, I wanted to give everybody an opportunity to speak before I did again, but I know that the release of craft grower license, or at least the idea of the craft grower, just came out Monday or Tuesday. So it probably bothers me more at the craft grower than the cultivation center, because I know what the cultivation center looks like. I know where the ones that are there existing now, I know the level of security. I believe that the craft grower is going to have some level of security as well, but it's undefined other than what the state has put forward. I mean, we don't have. I can't go find a craft grower today. I can't go. That doesn't exist in today's world. So that's why I'm kind of leaning to the A. Today, if we had to say, you've got to pass something, that's why I could lean towards A. Let's give it some time, and let's face it, every state that's legalized is sitting on, Oregon and Washington are sitting on multiple years worth of supply right now, and they've been legal for 4 years. I think Oregon, it was reported by the AP in September. Oregon's got a 6-year supply already. So I don't know that. I can tell you, if you let a farmer do it, they'll overproduce it. It's what they do. So a farmer isn't going to get a cultivation center. Let's be honest. But I'm really concerned that we are going to overproduce this, because we just will, and we'll be sitting on years worth of supplies, and we may have a spot out in the county that all of a sudden we can't really regulate. They shutter it. Now we've got a nuisance out there, out in the county that really doesn't. There's nobody to really push to get rid of it. I mean, we can't enforce a lot of things now. We have a hard time enforcing things. So that's why I say, B's not the end of the world, but I do agree with Ms. Eisenman that maybe you just keep it in the 1.5 miles to start, and we come back and revisit it, and we could always expand it if we needed to at a point later. Am I correct on that? So, and that would be my feeling as I've thought about it.
Thank you. Further discussion? Someone care to make a motion?
And you can,
Ms. Furtado. Go.
John, you could tell me to go jump in a lake for this question. Is there any way that we could at some point, because clearly we have a lot of time because this has to go to the ZBA, get a map that shows, particularly around the ones that have particular zoning requirements, like I just don't have a very good sense of how many properties are even eligible for some of these things. So like if we think about like the 1.5 miles and then we think about the zoning requirements, like is this something that could, like, I can't even, and then of course there's the limits on the permits, so we don't, obviously have any control over that. But how many potential even sites are there for some of this? I sometimes feel like I don't have a good picture of how much of the zoning for these different categories is even available based on this kind of map.
Well,
And
Mm.
again, as I said, you could tell me to go differently.
the county is 1,000 square miles. The municipalities, all of them added up, may take up 400 square miles. So 600 square miles.
Okay.
B would probably open up 600 square miles to cultivation centers and craft growers. Now, you could open it up just to cultivation centers and not allow craft growers more than 1.5 miles
Okay.
from Champaign and Urbana. But this option B is everywhere except not within 1.5 miles of any other municipality or any residential district. So not within 1.5 miles of Penfield, not within 1.5 miles of Seymour, not within 1.5 miles of Dewey, not
Okay.
within 1.5 miles of Foosland.
And so still with that, it's 600 square miles and all of that's zoned.
Ag 1,
Okay.
Ag 1.
Okay. Thanks. That's helpful for me because I'm like just trying to visualize it in my mind, like what exactly this would apply to. Okay.
Ms. Dillard Myers.
There it goes. So the objection is craft growers as opposed to, what was the other one? The cultivation centers. Now, craft grower is just like an individual who wants to grow and sell, and then the cultivation center is like corporation company. Am I correct? Correct me if I'm wrong.
Yeah, I actually don't know what a craft grower is going to look like. Obviously, they're not going to be as big as a cultivation center. It's meant to be a smaller scale, but I think they still have to have security. It can't be grown outside.
And is it 5,000 square feet?
I think that's it.
It's 5,000 something, but I don't.
5,000 in the beginning, but it can expand up to about 10,000, I think, over time.
Yeah, I can't remember. I read it and I've read so much
Whereas
stuff.
a cultivation center, I think, can be 200,000 square feet.
So if a farmer decides he's going to move into marijuana on his property and grow as a side hustle, we're going to stop him from doing it. And that's 600 square feet if he got that. Is that what you guys are saying? That you don't want any craft growers or cultivation centers in Champaign County if it's not within 1.5 miles of a city? Am I correct? I just want to make sure I'm understanding everybody.
I am voting on Amendment A, which keeps.
No, I have a question for Mr.
Oh, you were looking
Paul.
at me, sorry.
Is that what we're saying?
A would allow any of these businesses, but only within 1.5 miles of Champaign and Urbana.
Okay.
B would allow cultivation centers, craft growers, and transporters anywhere in the rural area, but not within 1.5 miles of a municipality that doesn't allow it, and not within 1.5 miles of a residential zoning district.
Okay. So if I'm Farmer John out on 1300 East and I want a side hustle as a craft grower, and we pass A, he wouldn't be able to do that, would he?
Not if he's beyond 1.5 miles from Champaign and Urbana.
Okay, that's my question. Thank you.
I just looked this up because I couldn't remember the number. I do want to say again, so the one concern, and Jim, I understand what you're saying, is that then kind of Connie, what you're saying, are we privileging like the large, you know what I mean? It's like, is it then unfair because people with a lot of capital could get into this, but medium, smaller size people wouldn't have the same ability? And
That's
we're
not
making that.
really what I'm saying.
Oh, okay. But I think that's what it would do.
Yeah, what I'm saying is, I don't think it's fair for the county to limit a farmer or a craft grower
Yeah.
if they want to grow a legal agricultural product in the state of Illinois, if it's legal. That's what I'm saying, and that's what A does.
And I will say this is, I just looked at, the other thing I did just look up, they're only issuing 40 craft grower licenses in the state this year by July. So our deliberations will mean there's no craft growers probably this year, because we're probably not going to be done talking about this. So it's not as if all of a sudden there's going to be 6 of these in Champaign County. We might not get any, or we might get 1. I doubt very much they're going to give us our county multiple.
Well, I think it's only going to happen in counties that are already, supportive. And if you look at really a lot of the crowd at the 2 dispensaries locally is because we don't have another dispensary within 50 miles. And so counties haven't approved it. So I think that's what pushes it to, so there's 40 licenses available. I could see, and I don't know who's going to apply for them. And I really don't know what kind of money it is. Yeah, unrefundable.
It's like 40K, I think, just to carry the license plus application fees.
Right.
Yeah.
Right. So it's not insignificant to begin with, but I mean, I could see, because our county has already made some inferences in that I could see us getting more licenses, because I don't see these outlying counties that have already pretty much said we're not interested. I don't see them wanting to do it, but you don't know. I mean, because we're Champaign County. We're not Vermilion. We're not Douglas. We're not Ford. We're not McLean. But those folks chose not to have dispensaries. So, and maybe they just didn't get them either. I didn't do that kind of in-depth research.
I guess I was just going to say we basically, maybe some people would say we're liberal in that we largely grant the uses that people want to do anyway, but with zoning and such, we regulate what people can and can't do anyway with their land, as far as like businesses. And to me, what this as a county is doing is no different than what Rantoul has done. And Rantoul's, I mean, whether or not we come to the same decision, but Rantoul has said, nope, the city's off limits. They have the authority. We as a county have the authority to do the same thing. The state is, or a variation of different levels of it. And again, this is for the unincorporated. So it's one of those, it's like, granted, everyone's vote has the same weight, but the unincorporated, I do not hear it clamoring for it. Again, I haven't personally heard it clamoring against it, but we've heard that there are people that don't want it in the unincorporated. So I guess I just ask people to keep that in mind. This isn't the villages, the incorporated villages, cities, they have done, can do their own thing. This is for everyone who lives outside of those areas.
John, I have a question for you, because we can do the quick math here. And so say there's a tie, 3 vote for A, 3 vote for B. What happens then? Because then at this level, it's dead.
Yeah,
Go ahead, Stephanie.
I mean, the perpetual tie in this committee, and I mean, part of it's my fault because of work. I would support, and again, I don't like to waste people's time, right? Like the public's time. But I would support sending both to the zoning board so it moves to that step, so we're not just sitting on it for another month with both of them. I hear everything you're saying. I would be more supportive of B, and I do see B as a compromise from what my actual position would be. So I don't want it to be like you're surprised later on when I would vote for B. But I would support moving both of them forward to the zoning board for the public comment part, unless folks think that's too confusing. So we could take action today and move this.
I'll just say right here, we can just kind of, instead of me calling, if we just speak, so long as we don't speak on top of one another. Instead of me having to call everybody on this topic anyway. So just go ahead, Jim. Mr. Goss.
No, John, 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 my question would be, would ZBA then just send us one? Yeah, that's
No,
my question.
no.
Will they just send both of them back with the comment? So then we may
I-
have to make the decision at
If you tell me to take these to ZBA, I will bring them both back. Now, one of them may have
a recommendation.
less than a full recommendation, and then you're free to do with that what you will. We have some flexibility there.
Go ahead, Connie.
What I was gonna say is that B is what was discussed at the full board meeting, and it's why we're back here discussing this. I understand come up with two options and all, and I like the addition of the 150. I mean, what is it? 115-mile radius that was like Wonderland zone. I like that was added because I thought Mr. McGuire was correct when he said that was a loophole. But overall, I don't think that we should, at this point in time, limit anyone's ability to grow marijuana in the county if it's done within the county's zoning and within, the limits of the county. And I think that to try and deny people access to economic development surrounding marijuana, as we can see, there was a line for a week, whether you want it, at your location or not. There's demand and supply. Demand drives supply, and right now supply is short, and supply is short in Champaign County, and it does not make no sense for you to deny someone who wants to come here and set up a grow operation when there's demand here. And that's tax dollars for the county, that's tax dollars for the cities, and tax dollars for the state. It's growth of the economy, and hopefully somebody will come to Illinois rather than leave Illinois, as we see it's been going on for the past 8 or 9 years. We've had a reduction in population, a reduction in companies wanting to move here to do business. And I don't think Champaign County should turn their nose up at any business legal wanting to come here and do, because we are a growing situation. We need employments. We need employment or employers to employ our people. And like I said, the line around New Med and the parking situation over at Sunnyside speaks volumes.
Just say a few more words here. I guess I remember the board meeting just slightly different in that we didn't really agree on anything. It was thrown out, and kind of the two ideas that were thrown out, the one by Mr. Vatraspati was the idea of not having the dispensaries out in the county. And then the other one, I think I maybe mentioned it, and maybe Mr. McGuire mentioned it, was kind of the idea of within the 1.5 miles. So I think that's kind of where those two came from, and that's what Mr. Hall has incorporated here, and he's kind of given us the two versions. I mean, the one has the 1.5 miles, because I think we kind of heard no one was necessarily, he's just put that in there in both of them, and then the other one is the idea of expanding farther out with everything but not dispensaries. So that's just my recollection.
John, how does it work if you would take both of these back to the ZBA?
Well, I would run them as two separate amendments so that it's very clear the comments we're getting, and the ZBA would make a recommendation in both. Later tonight on the agenda, there's a similar situation with the solar farm amendment where we took 2 cases there and we have both cases back, and now you can look at those. So it's not a lot of work at staff level because, we work them up together. It's easy to keep the comments separate. I don't see that as a problem. So I think it'd be easy to do.
How do you let the public know? Like, how do you let these unincorporated areas know that they don't have like an IGA to put it up so when they leave daily? Like, how do we let the communities that we need to hear from, the rural communities, be able to be aware of it?
Well, we would only advertise this in the News Gazette, legal advertisement. We'll send a notice out to every township and every municipality. That's the only way we ever get the word out like this. We have the press here tonight. They're going to get the word out, I know. I really don't know what to expect in terms of public turnout to this text amendment, public hearing of it. I imagine it could get quite large. That's limited by the size of our meeting room. Is that helpful?
I guess my fear is the people that we need to hear from aren't going to come and comment at it. Like, truly the ones that we're trying to have a voice for, the unincorporated, they're the ones that we need to hear from, and I don't think that they'll be the ones that show up. I know a few of them won't.
Well, honestly, if you have some feeling strong either way, you're going to show up at a ZBA hearing. When we've had big issue items, matter of fact, we don't usually get them done in a single night. So, I'm less worried about people coming but we've got to get the word out, and it's up to the 22 board members that sit on this board to get out the word as well. So we need to do our part as well to get folks out and so you can hear it. And if they don't have an opinion, that says a lot as well. But I don't think we're going to have an issue getting a crowd.
So does anyone care to make a motion at this point in time? One way or the other? Mr. Patterson?
Could I move both?
Yeah, Mr. Hall said you can, yeah, so go.
All right, then I would move both attachment A and attachment B.
Okay, is there a second? Seconded by Ms. Furtado. Okay. Before we vote, further discussion?
I guess
go
I'll
ahead,
just
Kyle.
say that, I definitely I support B more than A, but I do think that we should, because there is this process of having to send it back to ZBA and for them to send us something in the future, I think it just makes the most sense for us to just send them both now so that 3-4 months down the road, we're not doing the same thing.
Anything else before we vote? Seeing no more discussion, all in favor, please say aye. Aye.
Aye.
All opposed, nay. Okay. We'll forward both A and B to ZBA for public hearing, and then we'll see them both back.
Sure. We'll send out a notice to ELUC members.
Yeah. The question was if he'll send it out when goes to the ZBA so that the ELUC members will know. John said he would. Thank you. We will then move on to, just double check that 9 new business items to receive and place on file by ELUC committee to allow a 30-day review period. And as Mr. Hall said, A and B are both tied together. So I'll go ahead and read both of them, and then we'll open it up for discussion, and then, or unless somebody cares to make a motion right from the beginning on one or the other, and we'll go from there. But I'll read both of them, so bear with me. We have A, Zoning case 945-AT-19, amend the Champaign County zoning ordinance requirements for a photovoltaic solar farm in section 6.1.5B2 of the Champaign County zoning ordinance by adding the following requirements for any proposed photovoltaic solar farm that is located within 1.5 miles of a municipality. Part A, increase the minimum required time for municipal review as described in the legal advertisement. Part B, require municipal subdivision approval for any photovoltaic solar farm land lease exceeding 5 years when required by any relevant municipal authority that has an adopted comprehensive plan. Part C, amend section 8.2.3 to allow any PV solar farm authorized prior to the effective date of this amendment and that is in the process of being repaired to not lose its zoning right to operate. Part D, add new section 8.2.4 to allow any PV solar farm authorized prior to the effective date of this amendment to be constructed pursuant to the standard requirements of a zoning use permit, provided that the special use permit for the solar farm has not expired. And then we have B, zoning case 946-AT-19, amend the Champaign County zoning ordinance requirements for a photovoltaic solar farm in section 6.1.5B2 of the Champaign County zoning ordinance by adding the following requirements for any proposed photovoltaic solar farm that is located within 1.5 miles of a municipality. Part A, increase the minimum required separation between a PV solar farm and a municipal boundary from 0.5 miles to 1.5 miles. Part B, same as Part A in case 945-AT-19, increase minimum required time for municipal review as described in the legal advertisement. Part C, same as Part B in case 945, require municipal subdivision approval for any PV solar farm land lease exceeding 5 years when required by any relevant municipal authority that has an adopted comprehensive plan. Part D is the same as Part C in case 945. Amend section 8.2.3 to allow any PV solar farm authorized prior to the effective date of this amendment and that is in the process of being repaired to not lose its zoning right to operate. And Part E, which is the same as Part D in case 945, add new section 8.2.4 to allow any PV solar farm authorized prior to the effective date of this amendment to be constructed pursuant to the standard requirements of a zoning use permit, provided that the special use permit for the solar farm has not expired. So, Mr. Hall or Mr. Goss, go right ahead.
Yeah, I would move that we accept option B, which is basically the same as option A, except it moves the separation to 1.5 miles.
Is there a second? Ms. Eisman? Discussion. Mr. Hall, if you care to say anything now, or if any of the other committee members have anything. Mr. Goss made the mention of the only difference between the two. Or Mr. Patterson?
John, could you, of the solar farms we've approved, because right now we have the half-mile limitation. How many of the solar farms that we've approved have we done a waiver for that requirement?
The only one that didn't need a waiver was the Baywa. So you have done,
What about the one out in
oh,
kind of close to Rantoul, but not really close to anything?
no, you're right. The one in Ludlow Township, that did not require that waiver either.
Okay. And so how many have you done total?
I think there's been 6 in total,
Okay.
but there's only one of those that, 5 of those were community solar farms and only one got selected in the lottery.
Okay.
So the others aren't even eligible to be built yet.
Okay.
The one that got selected in the lottery, I think it was more than 1/2 mile from the village. Yeah. Yes, yes. Just a little bit outside.
So the Sydney and the Ludlow were the only two that didn't require the half-mile waiver?
Yes.
I guess so. So the way I see it, it's like 4 of the 6 that we've approved, we've done a waiver for a half mile, and it seems apparent that while that's on the books, that's something that we as a board are comfortable with waiving. And really, it goes to the logistics of setting up the solar farm. They have to be close to a what's the term I'm looking for?
Substation.
Substation, and substations only really exist close to villages. So the way I see this is that if we establish a rule that says that you can't build within a mile and a half of a municipality, um, any company that's looking to start a project, they're going to look through our ordinance, they're going to see that, and they're going to turn the page and they're going to move on. But for the companies that know that we waive those, they're going to have an inside track. And I think that that is creating a, for lack of a better term, a shady situation to where some people are going to be in the know and they're going to know how to get permits here, and other companies are going to miss the opportunity because they're not going to understand that that's something that we always waive. And if we know that we're going to waive it, why make it a rule? So I'm much more supportive of A. But yeah.
I have a point of clarification, and I apologize, I hadn't realized this on earlier versions of this. For the Part B on A and Part C on B, where it talks about that the city has the right to weigh in if they have a comprehensive plan, is that for any municipality within the 1.5 miles? Like, could you explain to me what that gives to the city and by what mile? And is that totally new?
It's actually already written into the ordinance back in section 13, but I actually like having that in either version because it makes that solar farm developer aware up front that just because he's doing a lease, there may be subdivision issues involved. No, it's technically a requirement already.
So that said, I will not support B.
B, of course, the villages, they like that. The idea that they have some more control, say, over what's going on outside in that mile and a half outside of their actual limit. To me, the idea that a company would bypass Champaign just because of the mile and a half versus half a mile. We already had all of them come in and ask for the waivers. If your company's worth anything as a company, you're going to know that you could potentially ask for a waiver. So I don't see that being a big deterrent if someone really wants to put a solar farm in this county. Someone wants to apply for another one. So and once again, it goes to the fact that the incorporated municipalities are granted some rights outside of their true boundary, but yet we, the county, are the zoning. But I have no problem giving them, the villages, that mile and a half to let them have maybe some extra say, or it's really and truly, I guess you could say it's maybe not extra say, it's just in the ordinance so that it puts a little more onto the companies when they're wanting to come in, that they have to. It definitely makes it a little bit harder for the companies, but that's not necessarily a bad thing because they are, if they want to build within that mile and a half of the village, well, the village may have some plans out there on down the road. So the mile and a half to me is fine to increase it from the. So I would support B. What it comes down to over A.
I don't know. I guess I keep seeing a trend here. It's the small villages that we sitting here represent, and they want to work with us. And that's part of our job as the county board, is to work with local governments so that we can have intergovernmental agreements. And so St. Joe, the mayor of St. Joe, the mayor of Mahomet, the mayor of Rantoul, Sydney Gifford, they've all written us and asked us to please do this. And so to vote against it is pretty much saying, no, we're not going to work with you. It's just making them aware of it, giving them more time to do it because they don't have the staff. On one of the ZBA, the statements, it said they didn't have anybody to open the mail, so they didn't know about the ZBA meeting until like a day or two before it. So it's just working with these small villages, and this is what they've asked us to do. And so I guess it's harder. It's hard for me to understand because I'm a small town, and so yeah, you work with where you're at, and this is what they're asking. And so maybe in the big town, that's not how it works. I don't know, but I'm willing to work with them. They've all written us letters asking us to give them this so that if they have a plan for their communities that are growing, like Mahomet, they should certainly have a right to know if a solar farm is wanting to come in and have plenty of time to be able to find out about it.
Go ahead, John. Yeah.
Going back to Mr. Patterson's comment, an astute wind farm developer, if the 946, the B is approved, an astute wind farm developer reading the ordinance would understand, well, even though it says there's a 1.5 mile separation, there's a lot of provisions for when that is waived. So the ordinance more or less advertises the fact that waivers, particularly of that particular requirement, are entirely possible. And in fact, there's even rules about how that waiver is to operate. So nonetheless, I take the point that a wind farm operator who just wants to find the easiest location would realize, well, maybe I don't want to do the waiver. But most of these wind farm developers, I think they understand that because of they need to be where a substation is, and if they have any knowledge of Midwest zoning, they know that there is this tug of war between the county and the municipality within that 1.5 miles. So I think an astute wind farm or a solar farm developer, is not going to be fooled by the ordinance. They're going to recognize, okay, I got to deal with a waiver, and we had a couple of our solar farm developers were very willing to deal with the municipalities. I think Tammy Fruling-Vogus made that clear. Some of them were very easy to work with. Some of them aren't. The ones that are easy to work with, generally, they won't avoid a situation like that. They'll just take it on. The other thing is we tried to make clear in the finding of fact that merely establishing this at 1.5 miles is not going to change the fact that there will be waivers. And the municipal reps who were at the public hearing, they recognize that. But to them, and this seems kind of funny to me, but I guess I get it. To them, it makes all the difference if that rule kicks in at 1.5 miles rather than something less than 1.5 miles. And they're happy with waivers, but they want to be involved the minute something gets within 1.5 miles. So
is this the same 1.5 miles we was talking about for? Well, I think we ought to give the people the 1.5 miles.
John, at the agenda meeting, did you not say that 945 tied at ZBA? So 945 at the ZBA tied, whereas B was not a tie.
B was not a tie. It was greater approval. Now, we don't have rules at the ZBA for when there's a tie on a text amendment. Yeah.
Just thought I'd bring that up. I mean, so ZBA anyway, I guess, saw A as being a little more controversial, at least by one person, obviously.
So here's the thing. We represent the unincorporated areas on this issue. Period. We don't represent the towns. I understand that they want it, but we have the zoning up to 0.5 mile. And to me, this is tricky because I am going to vote to every time unless there's some major environmental hazard or something like that within the 1.5 miles. So it can make St. Joe and Mahomet, and the board clearly is going to. I mean, we gave waivers for half a mile. So we can make St. Joe and Mahomet feel nice by giving them this, and then they just get to go through another step, and the result is going to be the same. But I think we should have zoning rules that reflect what is actually going to happen. And so that they get, I read through these comments really carefully, and I just, frankly, it wasn't compelling. And so I don't support it. I didn't support it before. I think to be blunt, even with the cannabis thing, the 1.5 mile, fine. But I mean, we oversee what we oversee. We should have zoning for that area. And I don't think that this is compelling, frankly, reading their comments.
Stephanie, I just want to say, and I totally respect what you're saying, but you don't live in these areas. You don't represent these people. They're not your constituents. They aren't casting the vote for you. Like, they're not your people. So that it infuriates me because I just want to scream and say, they're asking us for this just to work with them. If we're going to waive it, that's fine, but they want to be in on the process. So when you don't represent them, it's not going to compel you because it doesn't matter one way or another to you, but it matters to the people living there. But if what theirs, you said it didn't compel you. What they said didn't compel you, and so I'm saying to you, but it's not going. It doesn't matter as much to you as it does to them. You don't live there. You don't represent them.
And I would disagree wholeheartedly with you that we're just going to always waive it, because I think that blanket statement is completely wrong. There will be cases that we won't waive that. And I mean, I don't know what it is because we don't know where it is. But there will be a time to absolute anything. There is absolutely a time where we will not waive the 1.5 miles. And I mean, to say that's absolutely, we're going to waive it every time, that's not right either.
I guess I just want to sort of piggyback on what Stephanie was saying. Sure, like the business side, I'm kind of compelled, like you said, we've had a lot of applicants and they understand the waiver process. But I mean, I feel like this is very disingenuous to the municipalities to say, oh, we're going to do this 1.5 mile thing because you guys asked for it. But I mean, it's not going to get waived every time, but it's going to get waived. I mean, 4 of the 6 we've done, we've waived. It's going to get waived. There might be other issues, and there might be times where we don't waive it or don't approve something for other reasons, but it's going to get waived. And when it comes to this 1.5 miles, like, I mean, this comes from a place of frustration, but if they want to be a part of the process, then they should incorporate and be a village and make their own rules. But they've chosen to be an unincorporated to where they have lower taxes. So if you want to make your own decisions, incorporate and pay for it like the rest of us do.
They are incorporated. Sydney's incorporated.
No. We're talking about the unincorporated areas that were like the Biddu.
Well, then if you want them to incorporate, they're going to take the whole county. Well, yeah.
There you go.
So,
then they can make the decisions. But the issue I have is that a basic American principle is no taxation without representation. But right now we have areas of the county that bodies that do not represent that area are representing that area, and we represent that area. If the people there want to be represented by themselves, there is a process to do that.
Yeah. Okay. The idea that we would approve, I agree with Mr. Goss. Baywall, when it was first proposed, it looked a lot different than what we actually got. It was wrapped around Sydney. It was right up to Sydney. I don't know. I don't know because we didn't vote on that proposal. But when it first came out in the public, it got Sydney riled up. That's why Sydney originally was big time against it as a village. By the end, you weren't hearing a whole lot out of Sydney because they'd accomplished what they wanted. They'd kind of pushed it outside of that 1.5 miles, and they could live with it. I think that's my words. I mean, you talk to some of them in Sydney, and they would probably say, "No, we still don't want it." But we weren't hearing the uproar. To give the villages the 1.5 miles, I don't think they're so naive to know that that's going to automatically say that nothing is going to get, no solar farm is going to encroach in that 1.5 miles. They know that they don't have the final say. They are just asking that it be in there. It gives them a little more notice. It puts the potential developer a little more on notice that they need to work with them. And it makes it slightly harder. I mean, because if they want to build within that 1.5 miles, or even if they want to build within that 0.5 mile, and the village doesn't control it, no. But if they have if it's in the ordinance, it's another step that people, if they're doing their due diligence, whether it be on the ZBA or on the county board, have to rule in their head, okay, it's in the ordinance. Do I waive that? That extra mile is a little more of a potential buffer for any of the villages that are incorporated or out in the county. And again, I don't believe that they're naive to think that that's going to keep development from potentially coming within that. They can see the situation that where do the solar farms want to develop? Relatively near a substation. And where are the substations? Generally near populated areas, which means villages. So I can see it as, yes, it is just a feel good, but okay, maybe it doesn't ultimately change a whole lot, whether it be a 0.5 mile or a 1.5 miles. In the big scheme of things, maybe it doesn't. But if it is a feel good for the villages, what's it hurt to put it in the ordinance? I don't have a problem with it. So.
And maybe I misspoke or was too blunt earlier. When I was saying that they would all be approved within the 1.5 miles, I think I said something like, well, there might be an environmental reason. I know like there was one that we were looking at that you had environmental concerns. Is that I wouldn't vote no, and I don't think most people from our caucus would vote no simply because it was within that 1.5 miles, unless there was some compelling other reason for it. And I also want to be clear, like the other option already does have a compromise in that we gave them 2 ZBA meetings and more time so that these smaller agencies, and I think it was the Muhammad mayor, said, she really appreciated, or she appreciated that more time kind of thing, and said, spoke in support of the 1.5 miles, but also said some of these municipalities might one day regret asking for the 1.5 miles on certain projects once they have to get involved in it. And to Kyle's point, I do think there is something to say this taxation without representation. Not to be a complete nerd, but as an urban historian, like one of the things that I studied a lot in my life is this idea of cities not incorporating areas, but wanting say in those areas. And if you're not going to pay for the services in those areas, there's limits, I think, on the say that you get. There has to be somebody that has the say, and that is our body.
Further discussion, or do we want to take a vote? We do have the motion for B on the floor. It's been made and seconded. And John, if this ties, this would be going, since it goes out for the review.
This just sits here to ELUC for a month.
For just the month.
Mhm.
So if it ties, then it sits here for a month, and then it would be going to the
Well,
board after that, correct?
in that case, if it ties, I think my view is that the committee probably is not going to recommend it to the county board because your board
But
rules.
since it's held at ELUC, though.
Well, the whole purpose for holding it
Yeah.
at ELUC is to let the municipalities know what ELUC has come down in favor on, and now this is their time to protest or not.
Yeah. Okay. So, and since our board rules say a tie at ELUC for stuff that goes, since the next step, granted, it's a 30-day hold, but the next step is to the board. a tie would, in essence, just say, okay, we're going to hold it here for a month, but then it'll go to the, is what I'm, is this right? It would go to the board still, but just without recommendation, like we've already had, well, we had happen recently. I mean, within the last couple, what, 2-3 months, or,
I thought the board rules said when it's a tie at the committee.
yeah.
I thought the board rules said when it's a tie at the committee, it's dead. It doesn't get forwarded to the county
No,
board.
no, the board will say committee level, it advances to the board, but without recommendation.
Oh, okay, all right.
So that's what I'm saying. The only difference here is instead of it going straight to the board 2 weeks from now, is that it's there's a 30-day period within there, and then it would go to the. So is that not? Do you think that's a correct interpretation? I guess, or Mr. Goss,
yeah,
if
I
you have
mean,
input on that.
If let's say something at the committee of the whole ended up a tie, it goes to the county board meeting without recommendation. So this would be the same thing. We're just at a separate night. It would go to the board without recommendation.
That I just wanted to clear that up. That I'm at least I personally am thinking of that correctly. So, okay, go if you have.
Sorry, just to be perfectly frank, to some degree, it doesn't matter, because at the full board meeting, we could always amend out the thing. If this is the one that ends up going forward, if we tie on B and we send it to the full board, and I actually think this issue is important enough that it should be sent to the full board regardless. If we wanted to, we could always amend it from the floor, and B is the more comprehensive of the two. So if we want a robust conversation amongst the full board, B would be the one that would have to move.
I guess my question is, if we do amend it at the county board, does that require an additional waiting period? I'm sorry, we're just really killing you tonight.
I think that's a gray area, because you've advertised, you would end up telling the public that you're going to recommend this, and then when it gets to the board, you're going to revise it on the floor of the board. That's a gray area. I think if you can get a supermajority to go along with that, you could override any possible protest there may have been. But that's the whole point for having both of these. So if there's a chance that you would want to do that on the floor of the board, I would hope that both of these cases would be sent so that municipalities have a right to send in a protest on 945 if they want to. And if the board wants to approve 945, then they know they have to have a supermajority. I think otherwise you're getting into a gray area where there are questions that I can't answer.
Do you ever regret having to work with this committee? So can we vote to move both of them?
You can vote that. You don't have that motion on the floor.
Okay.
We could vote on the first one, turn it down and or pass it, but there's two different items on the agenda. So if we vote on B and it passes, that's not to say the floor wouldn't be open for a motion on A. I'm just saying a separate motion. So, okay. Oh, so we ready for the vote on B? Okay.
I just have a question. So for A, it has all of the same things, but is it only requiring those things if it's within 1.5 miles? Okay.
A keeps it at the present half mile.
Because that's why, okay, so
But
Champaign County zoning ordinance.
It's
by
not,
adding the following requirements
it's not,
for any
because the half
proposed-
mile is already in the existing ordinance. It doesn't mention the half mile.
Okay.
B is changing the half mile. That's the only difference in B.
Okay. I mean, it's just like, so the way I'm reading, Champaign County zoning ordinance by adding the following requirements for any proposed PV solar farm that is located within 1.5 miles of a municipality, and then it lists A through D. I read that as A through D only applies
I
if
see
you're
that.
within 1.5 miles.
I see what he's saying there. On the agenda anyway. Yeah, that maybe isn't. quite right. Is it? Or-
A adds the extra notice anytime it's
Oh.
within a mile and a half.
Okay.
But the
Yeah,
required
yeah.
separation is only a half a mile.
Yeah. That's right. That's right. Does that answer your question, Kyle? Yeah. Okay. Okay. Ready to vote on B as moved to approve B. It's been moved and seconded. All in favor, please say aye. Aye. All opposed, nay. I'm going to say that passed, or do we want a show of hands? Show of hands. Okay. All in favor of B. Okay, 1, 2, 3, 4. All opposed to B. I see 2, 4, 2. So B passed. Okay. Is there micro? Just turn it on.
I mean, I would like to move A because I think there's a very good chance that B is going to get defeated at the full board. And if it does, that means we gave them nothing, and at least A gives them something. So I am going to move motion A as well.
Ms. Furtado moves A. Mr. Patterson seconds A. Discussion. Probably. Oh, go ahead, Kyle. If you want to.
I just want to reiterate what Stephanie said. In fact, I'll go forward and pretty much guarantee that if only B goes through the full board, I think it's going to be defeated, and then we won't be giving them anything. So, like John recommended or discussed, I think we should really put both of these forward so that we can, because if we just defeat B at the board, then we're not giving the municipalities anything. And I don't think anybody here wants that.
Thank you. Further comments, real quick? Otherwise, we're probably discussed out on this topic. All in favor, please say aye. Aye. All opposed, nay. Okay, let's do a show of hands again. In favor. We're moving. We're voting on them separately, but to move them both forward. So, okay, I see 4 and against 2, so that one moves forward as well. Thank you. Now then, 9C, zoning case 948-AT-19, amend the Champaign County zoning ordinance by amending section 8.3.2 to authorize a variance to rebuild a non-conforming structure before the structure is damaged. Is there such a motion? Moved by Mr. Goss, seconded by Mr. Patterson. Discussion. John, do you want to speak to this just a little bit, or?
I would say this is one of our most common variances. We recently had a zoning board member who questioned the propriety of doing this before a structure is damaged. So that made critical getting it in front of the county board to make it clear that these variances can be requested before there is damage to the structure. And I know the city of Urbana had a question, does this mean that this could be the only variance someone would have to ask for? Yeah, you could get just a variance to rebuild the non-conforming structure. And I think this is the most critical amendment we can make to our ordinance at this time.
Thank you. Further discussion? Seeing none, all in favor, please say aye. Aye. All opposed, nay. Thank you, that passes. On then to 10, new business, items to be recommended to the county board. We have A, subdivision case 203-19, Liu subdivision, final plat approval of a 2-lot minor subdivision located in the east half of the northeast quarter of Section 8 of Township 17 North, Range 9 East of the 3rd Principal Meridian in Crittenden Township and commonly known as the Farmstead, located at 493 County Road 1400 East, Lono. And I'll make mention that the petitioner and her attorney are present if the committee should have some questions. Sure, go ahead, Mr. Goss.
So I represent the farm that's next door and would be willing to recuse myself if you felt like that was a conflict.
I don't see that being a conflict for a subdivision approval.
I just wanted to throw that out there. If you wanted me to recuse myself, I would be happy to do it.
Okay. So is there, do we want to have discussion first, or does someone care to make a motion? Move, Ms. Eisman has moved the motion. Is there a second? Seconded by Mr. Patterson. Discussion. Any questions? Or Mr. Hall, if you have anything you wish to say?
I would just like to point out that, could you make that motion include the adoption of the findings for the waiver? Just to put it on record that the committee recommend approval of the plat and the findings for the waiver.
Okay, so I make a motion to move it, to approve it, the plat and the findings for the waiver.
Okay. And Mr. Patterson, you still second that? Okay. Okay. So, yeah, I forgot you wanted that, John. Thank you. So we had, again, Ms. Eisman moves and Mr. Patterson second. Give you a second to find those, Jim.
The findings are on page 112. Understood.
Okay. Further discussion, or are we ready to vote? Ready to vote? All in favor, please say aye. Aye. All opposed, nay. Thank you. That passed unanimously. Make a note here. Okay, we have B, resolution authorizing collector, coordinator, and host site agreement for the 2020 residential electronics collections. Is there such a motion? Moved by Mr. Goss, seconded by Mr. Patterson. Discussion on this. Susan, do you have anything you want to add real quick?
No, this is the annual renewal of the contract.
Any discussion? Okay, all in favor, please say aye. All opposed, nay. Thank you. That passed unanimously. We have C, resolution authorizing 2020 residential electronics collection events and follow-up IEPA one-day household hazardous waste collection event cost sharing agreement between the County of Champaign, the City of Champaign, the City of Urbana, and the Village of Savoy. Is there such a motion? Moved by Mr. Patterson, seconded by Ms. Dillard Myers. Sorry, getting a little tongue-tied. Discussion on this, or Susan, did you want to add anything to this real quick?
Nothing to add. It's good to share costs. That's what this does.
Yep, Mr. Goss.
Susan, was there an issue with the household one? Was that a bad weather day, or or am I just thinking something totally different?
Last October's collection was a failure in part due to the contractor not being prepared with adequate capacity, adequate personnel, and only 2 lines when we had expected 4. They hadn't considered that we needed to move a certain number of vehicles through every 15 minutes. They're just used to showing up at a place and winging it. So it just didn't work.
Thank you. I knew there was something, and I just couldn't remember what that was. Thank you.
Further discussion, comments? Seeing none, all in favor, please say aye. Aye. All opposed, nay. Thank you. That is passed unanimously. Okay, we're to D, closed session pursuant to 5 ILCS 120/2C6 to consider the setting of a price for lease or sale of property owned by Champaign County. Is there such a motion? Moved by Mr. Goss, seconded by Mr. Patterson. Yeah, well, yeah, we do need a. Yeah, and we'll be moving into the other room. Go ahead, Mr. Patterson.
Do we not need to have more language in the motion? Because I know we usually specify
committee level,
who will be present. at least.
You do need to specify who will be present.
Go ahead, Mr. Goss, yeah, if you're willing.
Yeah, I would say that we would have Rita, John
Recording
Hall,
secretary.
recording secretary John Hall, all the
Planning and
board
zoning.
members, and Mr. Rosales, the county board chair.
Yeah. And that should be all we would need, correct, John? Yeah. Okay, so did you get that, Rita? Thank you. And I assume I'm sure you're fine with it. Okay, all in favor, please say aye. Oh, that's right, roll call. Yep, we better roll call it because it is closed session. That's right. So ask for the roll to be called, please.
Eisenman,
Yes.
Furtado, Goss,
Yes.
Patterson, Thorsland, Dillard Myers, and Esri.
Yes, and I'll just make note that we do have a few other items on the agenda, not much, but we will be back in session after this. But Yeah. Okay. Back in open session and ask for the roll to be called again to confirm that we still have a quorum, please.
Eisenman,
Here.
Furtado, Goss,
Yes.
Patterson, Thorsland, Dillard Myers, and Esri.
Here. Have the original members of the committee. Okay, we were on to 11, other business. We have A, the monthly reports. We have the February 2019, March 2019, April, May, June, July, and August of 2019. Thank you, John, for getting these done. I know you've been busy and haven't had time to get them done previously. Is there any discussion on these or anything that you would really want to point out, John?
Just remind the committee that this takes us through August, and our new zoning officer started in August. So the next round of monthly reports will reflect being back at a full staff level.
Good point. Thank you. If there's no further discussion, go ahead, Stephanie.
Just looking at all of these in a row like this, I want to commend you, the incredible
actually
work.
helped, yeah.
We are lucky for the work that the county does, and I know that we, as a committee, add more work to you all the time in our grand deliberations, but this is, just seeing all of these together, it's impressive what you do.
Well, 2019 is our biggest year for zoning cases for a long, long time. Susan Bergstrom did a fantastic job keeping up with all of the zoning cases. So it was a busy year, and, you know, the economy has been exploding, so that's a good thing.
Okay, if there's, go ahead, John.
It doesn't matter
Jim.
if there's a misspelling, correct?
We could,
No, but I'd like to know.
Page 155, it says Thomas Clarkson /Urban Golf and Country Club. I think it's Urbana. Golf.
Urbana, that's right.
And don't ask me why, it just jumped off the page.
Oh, I
sometimes
see it there,
those
yeah.
do that.
Thank you.
Okay, with no further discussion, we'll receive and place those on file. We are on to chair's report, of which I have none. Designation of items to be placed on the consent agenda. We have 10A, B, and C. And if there's no objection, we are adjourned. Thank you.